And just kind of our quick standard disclaimer, this presentation is for educational purposes only. It's not legal advice and does not create an attorney-client relationship. Also, we're providing a quick overview of this topic. If you're already a client and you have questions after where you get through, you can send us a ticket through our portal. If you're not a client but you'd like help with this issue, we'll have some information at the end on how you can sign up. And as always, we'll try to keep this information moving for you. So the topic today, as noted by Dan, is joint employment. Why do we have ongoing concerns, and kind of why overall do we even care about the issue of joint employment? Well, the answer is because this issue can really affect the bottom line of your business if you're not careful. It's kind of a sleeper issue that maybe not every employer thinks about, but it's something that should be on your radar. If you're unaware of the compliance issues that can come in with joint employment, or if you're out of compliance with issues affecting joint employment with your business, it could be devastatingly expensive for your organization. So you want to be aware of and avoid any potential liability regarding joint employment if possible. A big question with joint employment really is who's on the hook for the specific employees when one or more businesses are working together. I mean, this can be kind of a complex issue. It would be nice if there was somewhat of a, straight ahead silver bullet answer for the question in all situations, but as you're going to see today, a lot of different rules could potentially apply. So as a result, we're going to discuss an overview of the issue, some factors to watch, and then at the end, we're going to talk about some steps to take to protect your business. So even as part of a foundational starting to this discussion, let's just give maybe a quick example of a potential joint employment situation. Say that as a business owner, you own 2 restaurants. And let's say, just for discussion's sake, you've got 2 Subway franchises. So you're a restaurant owner, you've got 2, they're Subways, they're franchises. What if you keep the workforces of both of your restaurants completely separate? So you've got store 1, store 2, the employees never cross over. Is that going to be a risk with joint employment? Well, it depends. We're going to talk about that. Or what if you occasionally have staff that does cross over between the 2 different Subway restaurants that you own? Is that a joint employment risk? That's something we'll get into as well. So to start getting into those issues, we're going to begin with a broad overview of the joint employment doctrine, basically. So what does that mean? So under the joint employment doctrine, an employee formally employed by one employer, that's known as the primary employer, may be deemed constructively employed by another employer, the secondary joint employer, if that secondary employer exercises sufficient control over the terms and conditions of employment. That's sort of a broad definition. We're going to get into some details, but that's just something to kind of keep in mind as we go through this. And also think about joint employment risk can be a two-way street. It can be bad for both the alleged primary employer and the alleged secondary employer. It's not just the primary employer who could be at risk with joint employment issues. So that's something to think about as we go through this today and when you think about your working relationships with other businesses. To get into a little more detail, we also want to talk about horizontal versus vertical joint employment. Those are kind of fancy terms you may or may not have heard of, but it's worth just getting that little bit of information in as we start getting into this. So what's the difference between horizontal joint employment and vertical joint employment? So horizontal joint employment is going to look at the relationship between the 2 employers. Are they related? Are they associated somehow? So a horizontal joint employment scenario, to give it as an example, is what we had just talked about a few minutes ago, and that would be 2 different Subway franchises owned by the same person. That could be an example of horizontal joint employment. Some of the factors to look at would be shared management. Is there shared ownership? Is there shared control over the workers' working conditions? That's a factor to look at. And if in a situation like that, there is a determination of joint employment, then both employers, again, could be on the hook for employee compliance issues. Sitting next to horizontal joint employment is vertical joint employment. So that looks at the economic reality of the relationship between the employee and the primary or client employer. So what's a vertical joint employment scenario? That would be a worker being employed by an intermediary, such as a staffing agency, but then performs work for an end user client business. Some joint employment key factors to consider with vertical designation is whether the client employer controls the work. Do they hire and fire? Do they pay that worker directly? That's at their business. That's something that you want to look at in terms of relationships in that space, because again, that could result in both employers being jointly responsible for wage and hour compliance, those sorts of things. We're going to have some points as mentioned at the end to help any business, but we're going to talk about just right now some specific industries of concern. In other words, these are kind of three major industries across the country where there is an increased risk of joint employment issues coming into play. So first one, as we just sort of touched on with vertical joint employment, is staffing agencies and their client. Say you're a staffing company, you send your own employees to the client work site. How is that relationship going to be managed so that you can avoid joint employment? Or you're a construction general contractor and maybe you've got some subcontractors. Is there crossover between crews? That's something that you want to look at. Or you're a franchisor and you've got a number of franchisees out there. How much guidance are you providing to your franchisees as the franchisor? In each of these different industries that we're looking at, does one of the parties exercise too much control over the employees of the other party? That's a key question to consider in these specific industries. If yes, there's too much control, then a joint employment relationship could be determined. There can be some other factors in play as well, as we'll talk about. But those are just kind of some three of the bigger industries that we see this concern come up quite a bit. So reiterating our first question when we got going today, why do we even care about joint employment? And as noted, it's mainly because with joint employment, it can create new obligations for your business, and it can also create financial risk for your business. I mean, most employers and most business owners don't want to inadvertently create a joint employment relationship because of increased liability. That could mean less revenue, that could mean less growth, and it could also mean suddenly you're forced to take compliance steps for somebody's employees at a different company. That's why you want to look at avoiding risk with joint employment where you can. So what are some of the main joint employment risks that can come in? So there's shared legal liability. Think of something like a wage and hour claim. If two employers are determined to be joint employers of an employee, then that employee could go after both of those employers for like an overtime issue, for example, or OSHA safety violations. That could come into play. There can also be labor law issues. With labor law, think of an unfair labor practice that relates to union organizing activities. So if one employer gets hit with an unfair labor practices claim, it could be applied to another employer that's determined to be a joint employer as well. That could mean your company is then pulled into a collective bargaining situation, even if the workers aren't really your workers. So that's another reason to be very concerned about joint employment. With joint employment, there can also be an aggregation of employee numbers. So if two different employers are determined to be joint employers, their employee counts could be put together, and that could create new thresholds of compliance for those employers. For example, if there's a determination of joint employment between two employers and suddenly now they're at 50 or more employees, then under federal law, suddenly the FMLA comes into play for employees. The Affordable Care Act comes into play for employees. So that just creates more compliance obligations and more potential risk. Now let's talk about some of the different tests to consider when examining if a joint employment relationship exists between your company and another company. And again, we're going to give kind of an overview of all of these tests just because they're important. As we stated at the beginning, this is kind of a complex issue. It isn't really a one answer or one size fits all or a silver bullet. It's a bunch of different factors to consider. So based on that, it is important for us to go through some of these different tests just to get your mind into what are some of the things you should be looking at. So first off, we're going to start with the Federal Fair Labor Standards Act, or the FLSA, and how it looks at joint employment issues. So quick overview, the FLSA is a broad federal wage and hour law, covers minimum wage, overtime, record keeping, those sorts of things. So if there is a determination of joint employment under the Fair Labor Standards Act between a couple of different companies, that means the number of hours worked by an employee for each employer could be aggregated or added together. That can mean that suddenly there is overtime due under federal law for a worker. For example, if you've got somebody that works 37 hours at one job and then works 10 hours at another job, and both of those employers are determined to be joint employers, suddenly you've got 7 extra hours that need to be paid above 40 under federal law. Those 7 extra hours are going to be overtime. That could be a factor where both companies are on the hook for that issue and paying that overtime. So what are some of the joint employment factors that are considered under the Fair Labor Standards Act? So there's the economic realities of the employment relationship. So that could be things like control, how much control is exercised over the workers, and then also the totality of the circumstance, what's going on overall between and among the alleged joint employers. Is there control? Is there common management? Those sorts of things. Again, this matters because you could be on the hook for these federal wage and hour violations if joint employment is determined. Another joint employment test to look at is found under Title VII. And that means Title VII of the Civil Rights Act of 1964. That's a very broad federal employment law. It prohibits workplace discrimination based on race, color, religion, sex, or national origin. It applies to the hiring, firing, pay, promotions, and other terms of employment of an employee. Title VII is enforced by the EEOC, and we've got some EEOC information coming up. And if you're in a situation where a Title VII case is coming into play relating to joint employment, that is going to be examined through the Title VII lens, looking at things like the degree of control between and among the alleged joint employers. So how much does one employer direct the work of the employee of the other employer? The economic realities are going to be looked at. In other words, how closely are the businesses related? Are they economically dependent on each other? Is there a sharing of employees? Those are some of the factors that would be looked at for the economic realities. And then there could also be a totality of the circumstances, which would be a combination of control and the economic realities. So who has the power to hire and fire, who supervises and controls the employees, who determines the pay, who keeps the records. Those are some of the joint employment factors that could come into play if there is a Title VII claim affecting one or more potential joint employers. The Equal Employment Opportunity Commission, or EEOC, also puts out guidance relating to joint employment. So just as a quick refresher, the EEOC is a federal agency that enforces laws prohibiting workplace discrimination based on sex, race, color, religion, and sex. So in other words, the Title VII law we just talked about, the EEOC is an enforcement agency for those rules. The EEOC basically looks at factors that are similar to whether or not a worker is an employer or an independent contractor. So they're going to look at things like control, skill level, who provides the tools, those sorts of things. This matters because if there is some sort of like a discrimination claim coming against your business or another business where you've got workers kind of going back and forth, you want to be aware of whether or not and how they're going to examine that to determine if both businesses are going to be on the hook for some type of federal employment discrimination claim that the EEOC would look at. Another big federal compliance body and law to consider with joint employment potentially existing is the National Labor Relations Act. That's a very broad U.S. labor law that protects the rights of private sector employees to organize, form unions, bargain collectively, and engage in protected concerted activities for better working conditions. The NLRA applies to both union and non-union employers, and the NLRA is enforced by the NLRB, which is the National Labor Relations Board. So the National Labor Relations Board, there are members of the board that are appointed by the president, and they kind of tend to shift in their philosophies based on which philosophy of the current party that is in control of the presidency and the federal administration. So I give this background to give you some information on where we are now when you're looking at joint employment under the National Labor Relations Act. So currently, we're back to the 2020 rule, which we'll talk about in just a minute. As a side note here on the slide, the 2023 rule is gone. That's for now anyway, but we've got a different section coming up where we are going to talk about that 2023 rule, because just because it's gone for now doesn't mean it might not come back later, and it's something that we definitely want to have on our radar. So let's talk about the joint employment factors that are in place now with the NLRA under the 2020 rule. So in an enforcement action relating to joint employment, what the NLRB, again, in enforcing the NLRA is going to look at is they're going to look at control. They're going to look at who is controlling some aspects of employment of the employees between the employers. So they're going to look at wages, they're going to look at benefits, hours of work, hiring, firing, discipline, supervision, who's directing the employee. So the reason why this is important is if you're getting examined for joint employment under the National Labor Relations Act, if joint employment is found, that means both employers then are on the hook for potential labor law issues. We talked about this a little bit before, but an unfair labor practices claim that could draw in another company if you've got workers going back and forth with your company. That could also pull your company into a collective bargaining situation if the other company's employees are trying to organize a union, which is a humongous burden for your company. So you want to be aware of and try to avoid those issues if possible as it relates to that union stuff. There are also other rules. We've talked about some of the broad federal rules under Title VII, the Fair Labor Standards Act, the National Labor Relations Act, but there are also court-made rules, judge-made rules that affect joint employment that we just want to touch on as well. And again, the idea of showing you these rules is just to get your mind working on what do I need to look at, what do I need to consider, and to keep in your mind that yes, there are several different tests, there's several different avenues to look at. So amongst the federal circuit courts, there have been joint employment rules that have come through court decisions. So for example, a lot of federal circuit courts are using the economic realities test when they're looking at joint employment and determining if two or more employers are joint employers. So they're going to look at the power to hire and fire under the economic realities test. They're going to look at supervision, control, rates and methods of pay, employee record keeping. There's a list there of some of the federal circuits that look at those rules. Some of the other circuits use the rules that we discussed a couple slides ago for Title VII. The reason, again, for bringing this up is just to keep your mind on all the different avenues to consider with this issue. It's complex. We wish there was a silver bullet, but you want to be aware not just of these agencies that might enforce something, but also of federal court rules that could apply depending on what region of the country you're located in. On the state side of things, I think it's also worth mentioning as well that there are some states that have actually enacted laws to protect specifically franchisors and franchisees from a determination of joint employment. So again, these are some of the states, they're listed on the slide. They are meant to show at the state level under state law that the franchisee-franchisor relationship does not automatically mean joint employment exists. You'll note that these are some more business-friendly states across the country. If you were in a state that would be considered less business-friendly, for example, California, which is more employee-friendly, you would not have a law like this. It's important to note that there are states that are trying to protect businesses from that joint employment determination, just because it can be so burdensome for your company. But this is specifically in the franchise or franchisee area, and it's also specifically in these states that we've noted. We're going to hop back just a second to what we had talked about on the NLRA slide a couple pieces back, and we're going to talk now about that 2023 NLRA joint employer rule. That's why we say that joint employment is an ongoing concern. Not only is it a concern because of all the different rules and tests that you might look at as a business at both the federal and state level, but also because at the federal level, there was a pretty close call for employers with a 2023 rule under the NLRA that was put out to greatly expand who could be considered a joint employer under federal law. So right now, the reappearance of this rule isn't much of a concern, but maybe say 3 years from now, something like this is something that could come back. So that's why we want to talk about it. So with the 2023 NLRA standard that they put out there, 2 or more entities would be considered joint employers of a group of employees if they, number one, have an employment relationship with those employees, meaning the employees maybe are doing work in both places, and 2, they share or co-determine matters governing the employee's essential employment terms and conditions. So that means under this rule that had been put out in 2023, that say you've got 2 employers, if either of those 2 employers either directly or indirectly even have authority to control or even exercise control over at least one of the following enumerated essential employment terms and conditions, they could both be considered joint employers. So some of those essential terms and conditions would be wages, benefits, work hours and scheduling, assignment of duties, supervision and performance of duties, work rules and directions, hiring, firing, supervision, safety, those sorts of things. So with this very broad and very different 2023 rule, if an employer had indirect and even unexercised control of somebody else's workers, they could be considered a joint employer. And that could have happened even if that other employer never even exercised its authority to control any terms and conditions of the other employer's workers. It would have been a very, very broad expansion under the NLRA of who is a joint employer, meaning it would have pulled in all kinds of companies into union negotiations with workers of another company, even if they never really did anything with that company. That would have been a great upending of normal relationships between companies who do work together in any number of capacities. So I wanted to give you kind of an example of something that could have happened if this rule had gone forward. So say your business is a health clinic. You've arranged for a worker from a separate business. They do fire suppression equipment. They're going to come in and perform an inspection of your system. Because you're telling that fire alarm company employee when to work at your health clinic, there's an argument under this 2023 NLRA rule that your health clinic is now a joint employer with this fire suppression company under the NLRA. Why is that? It's because your clinic is exercising control over the fire alarm company employee's scheduling. You're telling him when to work, in other words, because you're saying, hey, come in at 10 a.m. on Monday morning to do your annual inspection of our fire suppression system in our clinic. Because you're controlling, quote unquote, that essential term of employment with the employee's scheduling, under that 2023 rule, the argument is that you're now a joint employer with them. That would have meant that your health clinic could have gotten pulled into collective bargaining or other union organizing activity with the fire suppression company because now you have indirect control or direct control over their scheduling. I mean, this, when you talk about it, it almost sounds like an absurd result. It almost sounds like it defies common sense. But that scenario was not out of the realm of possibility with that 2023 rule, and that rule was almost the enforceable law of the land. However, that rule was stopped by a federal court. The reason why we're discussing it, as just mentioned, however, is that this is something that could come back down the road. Again, watch this space in about 3 years to see if something like this comes back. That's why we're discussing it, so that you want to keep these issues in mind for the future. I also, in the joint employment space, want to provide a cautionary tale for employers. The case I'm going to discuss is Doe versus G6 Hospitality Property LLC. So this is a federal court case in U.S. District Court in the Western District of Washington State. So think of Seattle area. And there was a decision that came out on December 10th of 2025. So just a couple months ago, basically, that affects joint employment discussion. While this specifically relates to a franchisor and a franchisee, there is still information that is applicable when you're considering joint employment liability for your own business. So in this particular case, an individual brought a lawsuit against a hotel franchisee group. This franchisee group owns some hotels, and this individual alleged that those franchisees had violated a federal human trafficking law. This person was a victim of human trafficking, they said, and so they were suing the franchisee because of activities that occurred at those franchisee hotel property locations. But in this lawsuit, the plaintiff is also claiming that the franchisor, in other words, the big hotel corporation on top of the franchisees, should also be liable for what happened to her at those franchisee locations. So in this case, the plaintiff, or the victim of the trafficking, alleged victim, said, I'm first suing these franchisee locations because of what happened. They knew they should have stopped what was going on. I was damaged. I'm suing them. But her argument is that liability should not stop just with the franchisees, but liability should also extend up to the franchisor. She argues that the big corporation franchisor that is above the franchisee individual hotel location should be liable for what happened. Her theory of the franchisor being liable as well as the franchisee is based on the fact that the franchisor did exercise control over these franchisees to an extent that would put them in the joint employment sphere with the franchisees. In other words, the way the franchisor from the top down conducted business with these hotel franchisees, this plaintiff is saying, hey, because they were so involved with these franchisees, they are on the hook for this violation of law as well. So this basically means that there was an argument that because of the extent of the control that the franchisor did with the franchisees, that caused this issue to exist. So there were things like the reservation system. They told, the franchisor told the franchisee how to greet clients when they came in. There was all kinds of direction from the franchisor to the franchisee on public relations, how to work with law enforcement, things along those lines. So because of that amount of control exercised by the franchisor over the franchisee, the court is allowing now that the franchisor be brought into the case. Before, initially the case was just against the individual hotel franchisee locations where the alleged incidents occurred. Now the franchisor has been pulled into it because they exercised enough control over the franchisee's operation, again, with things like setting their room rates, what software to use, when to call the police, how to greet the guests, things like that. Because of that level of control, this particular judge said, yeah, you could bring the franchisor in. So the takeaway again is to look at control in your relationships with another business when you are considering if joint employment exists. So what to do? We've given you some rules. We've talked about some scenarios. Let's talk about assessing risk in this area with joint employment. You want to look at relevant legal authority as a starting point. We've gone through that because you're attending this webinar. You'll receive a copy of this PowerPoint. You see some of the broad points, but you want to look at which tests could be in place for my business to see whether or not I'm a joint employer. You also want to see beyond those broad federal agencies like the NLRB and the Department of Labor enforcing the FLSA. You want to see, well, are there any state or any federal court decisions that affect my relationship? And also, are there state rules that could, if I'm a franchisor and franchisee in one of these more business-friendly states, is there something that could protect me? You also want to look at the economic realities of your relationship with the employees of another employer. And how do you work together with these other employers? I mean, how much economic dependence is there? What do the factors that we discuss, what have they been showing? And then importantly, how much control is your business exercising over the employees of another company? Control could be a main factor in your analysis. We want to talk about risk reduction, and we're going to start specifically with kind of those three industries that are at a assessed higher risk of joint employment determination. With staffing, you want to consider, okay, who's supervising the staffed employees? For example, if you're a staffing firm listening today, it's a good idea, if possible, to have your own on-site managers handle direct supervision, performance issues, and disciplinary action of your employees that are placed at a client site. You also want to look at financial separation. A staffing company should keep sole control over the wage rates, benefits administration, payroll processing. Keeping those items separate helps limit your risk. If you work in construction, it's a good idea to have some field management protocols in place. In other words, you want to keep things at arm's length. With communication, for example, the general contractor superintendent directs the subcontractor's foreman. It's not the general contractor directing the subcontractor's employees directly. Should go through a foreman, for example. Also a good idea in construction to avoid cross-branding. If you're a general contractor, giving your branded workwear or safety gear to employees of subs, that can be risky from the joint employment point of view. For franchise employers, consider operational documents. It's a best practice for a franchisor to not state in your documents that you control the franchisee employees. It's also a good idea to have separation of control. In general, the franchisor provides the brand systems and operational information, and the franchisee supplies the employees. Franchisee pays them, franchisee manages them. Another area to talk about just briefly in the franchisor-franchisee space is the American Franchise Act. That's an active bill that's currently sitting in the U.S. House of Representatives. We discussed earlier some of those state laws that have been passed to help protect franchisors and franchisees from joint employment issues. This is a federal bill whose intention is to do that. It would help define the roles of the franchisor and the franchisee, and it would help limit liability by stating things like, hey, the franchisor and the franchisee, they're not on the hook for each other's employees, that sort of thing. It would help provide stability in that space, which would help with overall growth for businesses in that area. So for any business, what are some general best practices to consider when you're looking to limit or avoid joint employment liability? So if you're an employer and you don't want to get tagged as a joint employer, some of the things that you'd want to look at avoiding are the hiring and firing or providing input about hiring and firing to another employer. That's something just pretty basic on its surface, but something to think about. It's also a good idea to avoid supervising the other employer's employees directly or on a day-to-day basis. Not a good idea to discipline other employers' employees. Not a good idea to assign specific tasks to another employer's employees. Not a good idea to set compensation or other terms and condition of employment for someone else's workers. Not a good idea to participate in payroll and record keeping functions of somebody else's employees. Not a good idea to provide benefits to somebody else's employees. Understood some of this might not apply in all industries, but again, this is just a broad overview of some items to avoid doing. Also, you want to avoid retaining the right to implement workplace policies that you then apply to somebody else's workers. You probably also want to avoid requiring workers from someone else's company to attend your training. And you probably don't want to be going through another employer's records relating to their employees. Those are factors that, if examined in a claim situation, would provide evidence that you are actually a joint employer. It's not a good idea as well to treat another employer's employees as your own by doing things like providing business cards or giving them a company email account with your company. Requiring somebody else's employees to follow your employee handbook is not a good idea. Doing performance reviews or evaluations of someone else's employees is not recommended. And facilitating training or professional development for somebody else's workers also creates or increases your joint employment liability risks. Some of this stuff, as we talk about it, might sound sort of obvious, but it's just really out there so that you're thinking about how can you protect your bottom line and keep you out of some entanglements with other companies. Some affirmative steps to consider with avoiding joint employment would be clearly assigning responsibility and liability for compliance in an agreement you have with another company. You can also look at using indemnity protections to make sure that you're not going to be on the hook for something, or try to make sure, I should say. And why is this important? A written agreement or contract with another employer can go a long way to help limit your liability. You spell it out. We're not joint employers. This is what we do with our employees. This is what you do with your employees. That type of information in a written agreement can go a long way to getting a handle on the issues and addressing them up front, which is going to help limit your risk down the road. Now, we covered a lot of information here, but we want to also talk about how we at myHRcounsel can help you out. So first off, as always, run your questions through us. We're familiar with the shifting issues regarding joint employment. The guidance keeps evolving, but we're monitoring it. If you're not already subscribing to our weekly newsletter, I recommend that you do so. We'll have some information at the end on how you can contact us, but that is another good way to keep up on employment laws and trends in all issues, but including joint employment. And we also, for our clients, can advise on the best way to evaluate potential joint employment situations. We see these questions all the time. As we just discussed, there's a number of different rules. There are some big rules that almost changed and could change again that you just want to keep a handle on. Dan's also got some information for us here too to discuss.
Once again, thank you, Michael. Thank you, everyone, for attending today. If you have any questions about joint employment, as Michael said, we encourage our clients to open up a ticket in our Ask an Attorney portal so we can provide a specific legally backed answer. If you're not a client of ours and would like more information about how we can help you with upcoming changes, please email us at info@myHRcounsel.com. Additionally, We are looking forward to exhibiting next week at the International Franchise Association's 2026 annual convention. You can stop by our booth at booth number 1117. We'll have some representatives there. Additionally, in our email that will go out, we will have a meeting link. You can schedule a time to meet with our President and COO, Kevin Rohr. We are looking forward to exhibiting, and we hope that we will see a number of you there at the convention. And once again, thanks everyone for attending today. We hope to see you on another webinar in the future. Have a great rest of your day.